Welcome everyone. Kids Explainer May we are breaking down the absolute monumental shift from the old CrPC right into the brand new Bharatiya Nagarik Suraksha Sanhita, or the BNSS. And today we're focusing purely on the absolute bedrock of criminal law, first information reports, or FIRs. Because whether you are a law student or a practicing professional, you really need to know exactly how the rules of the game have changed.
So here's our game plan for today's explainer. We're covering FIRs under the new BNSS, the mandatory registration mandate, the incredible power of the zero FIR, digital access and EFIRs, and finally, how to deal with false FIRs. Let's just jump right in. Section 1. FIR under BNSS 2023. Okay, so if you're in the legal field, you probably know the traditional Section 154 of the CrPC by heart, right? Well, scratch that. It has now been entirely replaced by Section 173 of the BNSS. The structure is completely overhauled, sure, but the fundamental spirit of the FIR, that remains the absolute starting line of our justice system.
But before we get too deep, we have to establish the trigger, because everything, literally everything about an FIR rests on a cognizable offense, yani ek sangein aparadh. We're talking about a serious, non-bailable offense where the police can make an arrest without a warrant and just start investigating completely independently. No magistrate's order needed. That is the bedrock of Section 173.
Section 2. The mandatory registration mandate. Exam point of view se, the 2014 Lalita Kumari case is an absolute landmark. You cannot forget this one. The Supreme Court made it crystal clear that if the information given discloses a cognizable offense, the police have absolutely zero discretion. Registration of the FIR is 100% mandatory. They can't just say, oh, let us investigate first and see if we should register it. No, the FIR comes first.
Having said that, the law isn't entirely blind to nuance. BNSS Section 173, subsection 3 actually provides a very narrow window for a preliminary inquiry, but it comes with intense guardrails. It's only for specific offenses carrying 3 to 7 years of punishment. You need prior permission from an officer not below a DSP rank, and crucially, to stop the police from dragging their feet, this inquiry has to be wrapped up within 14 days.
So what happens in the real world when an officer just flat out refuses to register your FIR? The BNSS actually gives you a very clear hierarchical path. First, you approach the Superintendent of Police under Section 173.4. If that hits a dead end, you don't panic. You can file an application directly to the magistrate under Section 175.3 to compel the police to act. You've got to exhaust these steps before running to the higher courts.
Oh, and here is a fascinating recent update from the Kerala High Court about multiple FIRs. Imagine an FIR is registered, but you realize the police forgot a specific penal provision, like, say, Section 69 of the BNS. The court ruled that you can't just hit reset and trigger a brand new second FIR for the exact same incident. Criminal law cannot be set in motion afresh for the very same transaction just because the initial drafting seemed a bit weak.
Section 3. The power of zero FIR.
Historically, regular FIRs were heavily restricted by territorial jurisdiction. If a crime didn't happen in a police station's specific area, they would literally just turn you away. But the zero FIR completely destroys those old, frustrating boundaries. It gets registered anywhere, numbered 0, and then officially transferred to the correct jurisdiction. It's a total game changer. Now, this concept was born out of the absolute tragedy of the 2012 Nirboya case and heavily recommended by the Justice Verma Committee. But what you really need to note here is that while older laws lacked a formal definition, BNSS Section 173.1 finally gives it a strict statutory mandate. It explicitly says, irrespective of the area where the offense is committed. This guarantees swift action and vital evidence preservation.
And guys, the law has serious teeth to back this up now. Under Section 199C of the new BNS, any public servant who refuses to record this information faces a minimum of 6 months rigorous imprisonment. 6 months! And it can extend up to 2 years, plus a fine. Refusing a zero FIR is literally a serious crime in itself now.
Section 4. Digital access and EFIRs. Which brings us to a really fun, modern legal question. Let's say you're an Indian citizen sitting in a cafe in Australia. Can you legally trigger an FIR back in India for a crime committed at home?
The answer is a resounding yes. In the recent Soya Anthony case, a woman emailed a complaint all the way from Australia. Local police refused it because it lacked a physical signature. Well, the Kerala High Court categorically struck that refusal down.
They ruled that the actual content of your complaint matters way more than a physical signature or how you send it. You simply cannot deny access to justice based on procedural technicalities. The BNSS perfectly embraces this shift. You can now officially give information via electronic communication. The only catch, to stop people from spamming the system, is that the electronic record must be physically signed within 3 days. And here's a brilliant transparency update under Section 173(2). A free copy of the FIR must now be provided to both the informant and the victim. Section 5. Dealing with false FIRs. Now, with all this incredible digital access, there is a dark side. When someone weaponizes these laws to file a malicious FIR, an innocent party suddenly faces the horrific threat of wrongful arrest. Their immediate life-saving remedy is seeking anticipatory bail. Right after that, to permanently kill the fake case, the accused has to run to the High Court and file a quashing petition, using the inherent powers now housed under Section 528 of the BNSS. But the system doesn't just let the liars walk away. The new Bharatiya Nyaya Sanhita strikes back, and it strikes hard. Look at Section 212. Furnishing false info can get you up to 2 years in prison. And Section 216 is even more aggressive. Making a false statement on oath to a public servant, that threatens up to 3 years of jail time. And honestly, the courts are just fed up with it. In the Varun Baga case, the High Court straight up observed that it's become commonplace to misuse the legal system and submit false FIRs just to stroke someone's ego. It's a massive burden on our justice system, and it ties up the police and the courts, which is exactly why these strict new penalties are absolutely crucial. So we've walked through mandatory registration, the borderless power of zero FIRs, global digital reach, and the strict new penalties for lying. I want to leave you with this final massive question. As future legal professionals, do you actually think the BNSS has found the perfect balance? Have we successfully armed victims with digital reporting power while still protecting the innocent? It is a question that's going to be tested in our courts for years to come. Thanks for joining me on this explainer, and keep questioning the law.